Good afternoon. Good afternoon. How are we doing today? Good afternoon, Chelsea. We doing okay? We holding it together? All right. So, got a couple more people who still waiting for the handshake to finish so that they can hear the audio, and then we'll give them just a few seconds and get started. So. Okay, so let's get started. And as we usually do, I want to start by checking in with you guys, making sure that last week's lectures made sense to you and that what you're getting out of them is what I think you're getting out of them. So, what do you feel like you learned last week in the lecture? And uh, is there anything, what's still unclear about the lecture from last week?
Well, sir, I now got back from doing the survey things, so I'm now playing catch up. So when I watch the lectures and stuff, I will give you an answer, I guess.
Okay, that's fine. The question isn't directed at anyone in particular, so anyone should feel free. So everyone should feel free to jump in on this. So.
Sir, can you repeat what you said?
Sure. So there's two things. The first one is, what did you learn last week? And you can't get free of that just by going, well, everything was clear. Okay, great. What was it that was
we
clear?
do defenses?
Defenses are this week. Yeah. So, so the first question is, what do you feel like you took away from last week's lecture? And then the second thing is, what is it that you're still confused about? What is it that may not be as clear from last week's lecture?
So just to clarify, right, the last week lecture was on remoteness and excal plaintiff rule.
Mm-hmm.
Okay, cool. To me, everything seemed understandable. So at this point in time, I have no questions. I still need to do some reading. So probably when I read, I might have more questions.
Well, I understand, this is, but, one of the things that is an important piece of the puzzle is making sure that you don't fall too far behind on the reading, right? It's, these things happen, life happens. I understand that, there are times when um, you have other priorities in your life, and I will never, I am not one to tell you that that's wrong and you should always treat my class as your highest priority. I think that you guys are adults and you guys are allowed to decide that other things are more important. Um, One of the things that happens when you do that is that sometimes there are consequences, and those consequences can include, coming to the tutorial and not really knowing what has been covered because you haven't done the reading, and that's okay. I don't want you to think that I'm um, upset at you. I just want you to understand that, like, this is, the but for cause of you not being able to answer the question is because other things were a higher priority for you. Sal.
Hey, sir. So from last week, I based on reviewing my notes and rewatching the lecture and stuff like that,
Mhm.
I know that we went through remoteness on the Monday, and then we went through the egg skulls principle on the next day. But what I am confused about as it relates to remoteness, I understand that we look at how we look at the external factors. So when we were looking to how as it relates to how to determine foreseeable harm, we went through and we look at the external factors and the causes and stuff like that. And I know that we went through two cases, which was the Hughes v. Lord Advocate and the Doughty versus Turner. And we use those as comparative cases. But I am still not very clear as it relates to the different principles that came out of these two cases. And then secondly, when we look at the egg skull principle, we compared it to the superseding events, right? And how it interacts with the superseding events, but I'm still not clear as to how the two interact with each other.
Sure. Okay. So one of the things that we have to keep in mind is that neither Hughes nor Doty are completely accurate statements of the modern doctrine. Okay, and one of the things that is sort of puzzling about teaching this area of law in this region at this time is that for decades, this course material was taught with basically exclusive reference to cases from the House of Lords and from the Privy Council. And very frequently they were West Indies cases, so they were, sort of cases from the region, but they were being decided by their lordships in London. The issue is that the courts in the United Kingdom have continued to develop the doctrine, but some of the Caribbean has stopped looking to London, right? Barbados in particular being the example that comes to mind. I know there are other states, but I can't remember which ones, right, that have accepted the jurisdiction of the CCJ as the court of last resort. What that means for, post 2008 cases from the United Kingdom is difficult to say, right? So this is part of why reception is such a complicated concept in this region. But here is my understanding of the doctrine as stated by their lordships. Because all of this is building up to a case from the United Kingdom from 2016. There are 3 steps in the remoteness analysis. Okay. And you can follow these 3 steps in the Hughes case and in the Doty case, and I think you can reach the same result. So this doesn't really change the doctrine, it just expresses it more clearly. Okay, so this is an awful lot of windup, but let me give you the test. Okay, the 3 questions that you ask are: is the instrument of harm one that is a reasonable source of danger? Okay, this is usually a very simple and straightforward question, right? The example that I gave in the lecture is a car is probably a reasonable source of danger. A cucumber might not be, right? The second step in the analysis is you're asking whether the mechanism of the harm was reasonably foreseeable. And if you may recall, right, Ward called this the Daftness Test. And certainly no court has ever called it that, but I think that's a really helpful phrasing for you guys to sort of wrap your heads around. Is the story that we're telling just totally daft, right? And if the answer is yes, maybe the harm was not reasonably foreseeable. Okay. And then the last question is, was the type of harm reasonably foreseeable? And most of the time, this is a relatively straightforward question, right? When someone is hurt in a car wreck, we expect to see damage to property being damage to the car, and we expect to see damage to the person. And so those two kinds of damage would be reasonably foreseeable. Pure economic loss may not be, right? So lost wages from being unable to work due to the car wreck, those may not be foreseeable, right? Certainly a closer question. So I've rambled for so long, I've forgotten who asked this question to begin with.
It's me, sir, Nikita.
Oh, Nikita, thank you. I'm so sorry. Does that sort of help you make sense of the remoteness issue? The key thing is not like the Hughes or the Doty. Both of those are just examples. The key thing are these three questions.
Okay, sir, I'm good. I'm good on that.
Okay. And now, I'm so sorry, remind me of your other question.
The interaction between the
Excal
principle
and superseding
the,
cause,
yeah.
right? Got it. Thank you for reminding me. Okay. I think that this may help you understand this and give you some insight into the broader issue. When we ask questions about but-for causation, and I'm getting to your question. So when we ask questions about but-for causation, we are engaged in a backward-looking analysis. We're looking at the harm that was done to the plaintiff, and we say, okay, this harm came about. It is an effect. What caused it? Okay, this thing caused it. What caused that? What caused that? What caused that? And so on back in time until we reach the defendant's negligence. And when we're doing the but-for analysis, we're not really concerned about how many steps we have to go through to get to the defendant's negligence, except in the event of an intervening cause. Okay. Remoteness asks a forward-looking analysis. So we start at the defendant's negligence and we ask, would someone who did this thing, this negligent thing, would they have foreseen the harm that the plaintiff is complaining about? Okay, so think about the facts in the Palsgraf case. Okay, Mrs. Palsgraf is complaining of getting hit in the head by a scale that fell off the wall. Well, let's do the causation analysis. Why did the scales fall off the wall? They fell off the wall because of the shock wave from the explosion. Why did the explosion take place? The explosion took place because the passenger dropped fireworks onto the tracks, right? Why did the passenger drop fireworks onto the tracks? Because the railway, through their guard, was negligently pulling the passenger onto the train. Okay, so that's the causal analysis. We've worked backwards from the harm to Mrs. Palsgraf and found a causal chain to the defendant's negligence. But now we turn it around and we do the remoteness analysis, and we start by asking, okay, the railway guard is pulling this guy onto the train, and even if he knew that there was a risk of an explosion, right, or should have known that there was a risk of an explosion, would he have foreseen that that explosion would harm Mrs. Palsgraf, standing way down at the other end of the platform? Okay. And Justice Andrews and every jurisdiction in the Commonwealth says yes, right? Because the inquiry is limited to what's the type of harm. Okay, was the type of harm reasonably foreseeable? And because it was harm to Mrs. Palsgraf's person, the railway guard should have foreseen that people's bodies could be harmed by this negligent act. And so the fact that the person whose body was harmed was 20 yards away, not relevant. Justice Cardozo says, look, you know, the sort of bubble of foreseeability is quite close. It's the people who are directly affected by this negligent act. It's not people down the street. Okay? So when we have an egg skull plaintiff, bet you thought I'd forgotten. When we have an egg skull plaintiff, okay, what we are asking is if the defendant had recognized the vulnerability, had understood that the plaintiff was vulnerable, would the defendant have foreseen the harm that was done? Okay. And so under the egg skull plaintiff principle, the defendant has to take the plaintiff as they find them, and, you know, should have known that there are people out in the world who are vulnerable and who can take special harm from a negligent act. Superseding cause says, okay, but the vulnerability doesn't exist at the time of negligence. And so how would a defendant have foreseen that later in the future, the plaintiff becomes vulnerable and gets this extra damage? And so that's why in the egg skull plaintiff rule, where the vulnerability exists at the time of the negligence, we allow the special recovery. And in a superseding cause case where the vulnerability arises after the negligent act, we do not allow recovery. Okay, does this help, Nikita? Do you feel clearer
Yes,
now?
yes, sir. Yes, sir. That was good actually. Thank you.
Yes. Oh, that's like, oh, it's like honey in my ears. No, that's okay. Moving on. So any other questions before we move on? Last chance for questions. 3, 2, 1. Okay. So now we're going to spend the rest of today talking about the tutorial question. And let me put it in the chat for you guys. Would like you to describe for a client how causation is established in cases of negligence. So this has been on e-learning for several days. I know that some of you have been busy and you've been, there are other things on your plate, and certainly it's law week, and so you may be more distracted than usual. If you guys need a few minutes to gather your thoughts on this, you're welcome to them. Otherwise, we can jump right in. So which would you prefer? So the collective action dilemma here is that nobody wants to be the first one to say, I need some time. Okay, so we'll take a few minutes. Just a couple of tips, right? The key piece of this question that I think should inform how you think about it is the phrase "for a client." Think about it. A lot of your clients are not going to be terribly sophisticated in these kinds of cases. You know, it's very possible that this is the first time they've ever interacted with the legal system. So it's really important for us as lawyers to be focused in on making sure that we are communicating with clients at their level and not at our level. And that's really hard, but I want you to keep it in mind. Some things that I've noticed that are really effective, right? Clients like examples, clients like things that are really concrete, and jargon is fine. Clients can understand jargon, but you have to immediately define it the first time you use it. Okay? So with that in mind, I'm going to shut up for a few minutes, and then we'll reconvene in a little bit, and we'll hear what you guys have come up with. Okay? I will still be here, so if you need me, just pop in the chat, and I will be happy to help. Okay? Okay, so welcome back. We are back on the record. Destiny says causation can be established in cases of negligence if the person had a duty of care and it was breached. So let's just say that, you know, I'm somebody who's been living out in the bush all my life, and I come into Destiny's office, and this is what she says to me. Where am I confused? I don't know, Alicia, can it? I mean, you're explaining to a client. If you're asking your client questions about the law, that's a different problem. So can it be established using the but-for test? What do you think? Okay, what's the but-for test? Nikita, you're muted if you were trying to say something. Go ahead, Alicia.
Right, so the but-for test is when you ask the question, if the damage would have occurred but for the defendant's action.
What's damage?
Well, the negligence, sorry.
What's negligence? I hope I'm not trying to put you guys on the spot. But my point is that these are things that have to be broken down and explained very simply for unsophisticated clients. And they're things that, like, you guys may take for granted because you've been immersed in this even just for a year, right? It's easy, things that are easy for me to take for granted because I've been immersed in this for 15 years, okay? But when the client walks in and they've never interacted with the legal system at all, they've never had an explanation of any of this, you have to start from scratch. You have to, as Akeem says in the chat, you have to define negligence. You have to ask, what is, what are we even here to talk about, right? You really have to break it down, okay? Now, you also have to be smart about the fact that this is an exam question, okay, right? So an exam question is asking for a specific call, and the call specifically in this case is about causation. Okay, so certainly you may want to, explain negligence, explain the duty of care, explain breach, because this is part and parcel of the process. But at the end of the day, if you submit, if this was an actual exam question and you submitted an answer that talked about duty and breach, no marks. Well, some marks, because I tend to give marks for correct answers that aren't really responsive, but nowhere close to full marks. Okay, so how do you explain to your client the concept of causation?
Can I give it a try?
Yeah, go ahead. Go ahead, Jade.
I was thinking that you could basically say, well, why did you get hurt? Or why does anybody get hurt? That is basic causation. And then you can go on to explain to the client, well, you have to look at the fact that the person that hurt you, should they not have hurt you, or does it really not matter? And then, okay, if they should not have hurt you, when the way that they acted, would it really have caused the harm or the hurt that happened to you, or was it for some other reason at the end of the day? And then if that harm that happened to you, or the hurt that happened to you, was it because they didn't take enough care to make sure that you didn't get hurt, or was it that they just acted however they wanted and then you ended up getting hurt?
So I think this is excellent. I think you've done a very nice job here of laying this out. The only thing that I can think of to offer, and when you're actually talking to a client, you certainly can talk about their case, right, in a way that makes it concrete, that is not necessarily available when I just say, explain it to a client, right? But concrete examples are always going to be good, right? So the example that I came up with that doesn't have anything to do with a case, you can just sort of use it regardless of what what you know about your client's case, is, you go down to a cricket match, okay, and you're seated in the stands watching the match, but you get distracted by something and you look away, and while you're looking away, something happens that's exciting on the oval, and the crowd stands up and cheers. And then you sort of get brought back by the noise and you see everyone standing up around you. And so you stand up and you're trying to see what was going on, okay? What was the cause of you standing up? Well, we can describe it as being the people around you standing up and blocking your view, or we can trace back another step in the causal chain, and we can say that the but-for cause for you standing up was something exciting happening on the oval that everyone else wanted to stand up and watch. Okay, so Jade, I think that was really outstanding. I think it was a little abstract, so I would encourage you when you're offering this explanation to a client to add some sort of concrete example, either drawing on their case that they've told you about or like the one that I offered. Okay, but very, very well done. Okay, have a private message here that the but-for test states in ordinary terms that an injury would not have occurred but for the defendant's absence of their duty to you. To which my answer, as you know, as the unsophisticated client in this scenario, is, what's a duty? And I think that this, and again, this is not a criticism of the person who sent me this. I think that, you know, part of the puzzle here is figuring out what are the things that need to be explained to clients. And sometimes they tell you, right? Sometimes they go, I don't understand this thing that you said. A lot of times clients are embarrassed to admit they don't know something. And so it's important for you to sort of be able to look ahead of your words and figure out, okay, these are the things that I wouldn't know if I had not gone to the Faculty of Law, right? Okay. Anyone want to go next? This is a hard activity, guys. I really appreciate the work that you've put into this. So don't be discouraged if you put yourself out there and I kind of pick it apart a little bit. This is hard stuff. So, anybody want to go next? No, nobody? Okay. What questions do you have about all of this? What questions do you have? Silence can sometimes be the sound of thinking, so I try and give you guys time if you, in case somebody is trying to formulate something. No questions? Questions going once? Questions going twice? Okay, so we're going to wrap this up a little bit early. If anyone wants to email me what they've come up with for their client explanation on this, on this topic, I will, just like we did last week. Sorry, go ahead, Alicia.
So to answer the question, we so we have to like state and explain all the like all the terms.
No,
That's
only the
what you're
only the ones that you use.
well, okay, all right. Um, so we have to include the but-for test and the proximity test also when explaining the causation and negligence.
If you think that those are parts of what your client would need to know, yes, absolutely. You know, but for example, right, if you think about Jade's explanation, Jade never even used the term but for, never used the term proximity. She did include what those tests are in the explanation, but those terms didn't appear, right? And that's part of what I think is really powerful about how Jade approached this, was that she didn't use the jargon. She explained it in the kinds of terms that, you know, the guy down at the rum shop would understand. Maybe even a couple of drinks in. So I really I think that was a very effective approach, but it's by no means the only approach. Okay, so I don't want to tell you that you have to imitate Jade. I just want to tell you that I think that that is one way that would be that was very effective. Yeah, Kami says basically just explaining it in the most basic terms possible in order for somebody else to understand. Yeah, right. Break it down as much as you can. Don't include things that aren't necessary, and just really get it down to essentials explained as simply as possible. I will let you in on a little secret. These explanations, if they're really effective, work on judges as well. Judges love being told that something is very simple and very easy, and then having it explained to them in such a way that they go, yeah, that's right. They love that. Okay. So never met a judge who didn't go, I would love it if you could explain this to me like I'm 5 years old. So uh
Sir,
so that,
so
yes, go ahead. Go ahead,
sir,
Nikita.
so in when you go to court, they don't expect to speak the jargon of the profession?
So, okay. The answer to that is you absolutely do need to know the jargon of the profession. But the judge is going to be, I've never met a judge who is not delighted to be told the but-for test is about drawing a connection between the defendant's negligence and the plaintiff's harm. And that's it, right? If you can sell that to the judge, you're going to be the judge's best friend, because you've just made their task much simpler. So does that answer your question, Nikita? I don't know if it does.
Yeah, yes, sir.
Okay. Alicia, you came off mute. Go ahead.
If we're answering this question for an exam, how many words would it be, like the limit?
My best answer to those questions is always enough. And that's not terribly helpful. But in general, like I put word limits on exam questions that are much longer than necessary to accommodate the fact that I know that you guys are pretty verbose, but are not unreasonably long. So, for example, if I give you a 2,000 word limit on an exam question, my model answer, which is going to be fairly minimal and may not include like all of the steps of the analysis, but just sort of note that they have to take place. My model answer is probably between 300 and 600 words. Okay. So if I were asking you to explain something, for a client, some of it would depend on the scope of what you were being asked to do. I think that you can probably come up with a client-oriented explanation of causation, probably in less than 100 words. Certainly less than 500. In fact, if you're explaining anything to a client with more than 500 words, you've probably lost them. Does that answer your question, Alicia?
Yes, sir. Thank you.
Okay. So, what other questions are there before we wrap it up? Nothing else? Last chance. Okay. So we're going to call it a day. Like I said a few minutes ago, if you want to send me your client explanation via email, I will be happy to shoot you some quick comments on it, and we'll see you tomorrow. Okay, we're gonna. I should tell you guys, we are going to talk about assessments tomorrow. So we will. Those have been approved, but I don't want to repeat myself 7 times explaining them in the tutorial. So we're going to do it in the lecture. So we'll talk about that first thing tomorrow. Okay. So yes,
Sir,
Alicia. Yes, go ahead.
Assessments is not next week, right? Just week after.
The syllabus says next week. That is one of the things that we're going to discuss to nail down. If we need to push it back a week, I don't have a problem doing that, but we'll have that conversation tomorrow.
Okay, no problem. Thank you.
No problem. All right, take care. Bye, guys.